years ago, 10 years ago, everyone in this audience would have thought that I had somehow mispronounced pound sign, right? So what does that mean? It means that we've changed. We've changed enormously just in 5 years. So that's what this conference is really about. It's about learning to modernize approaches to the practice of law, and cliche though it may be, how to think out of the box about the practice of law. Today's and tomorrow's attorneys are their most successful when they reimagine what legal practice can be and bring fresh new ideas to the legal industry. And one of the reasons it's so important to have students here and students in the crowd and students engaged in this conversation is because you bring those fresh new ideas. Some consider these innovations and disruptions unwelcome, and there's resistance. Some of you may have noticed that there's a resistance to moving ahead in some ways. Why do you think this is? Well, we're lawyers. Law schools train us to look to the past for our answers. We're not looking to the future for our answers, we're looking to the past. We're looking at precedent, we're looking at laws that have already been put in place. That's really inventive sound. All right. We're looking at laws that have been put in place. Precedent is our foundation. It's how we predict the outcomes for our clients. It's how law schools teach us to navigate the legal system. Change is a challenge for those who labor to fit our already rapidly changing technologies and their impacts into our current system of rules and case law. It's also the greatest opportunity in the last century for legal and the legal industry. We have some societal challenges facing us. Racial bias and discrimination, climate change, access to justice, social justice, maintaining personal privacy, just to name a few. Is technology and innovation the magic pill that'll make all these things go away? No. No, but it can help, and it is an opportunity. And it's an opportunity to rethink how we engage the law, how we engage clients. What is the job of a lawyer? And we're going to address some of those questions today. We're going to talk about them, we're going to think about them, and hopefully after this conference is over, you're going to take some new ideas back to your practice, back to your classroom, and you're going to implement those new ideas. Today we'll hear about how the law impacts and will impact technology, and how technology is impacting the legal industry. We'll lift the cover and offer a peek at the new tools available to lawyers and the new ways you can use your JD. We'll think about the pressing issues of our time and tackle those problems with technology and innovation. We have an exciting day ahead of us, filled with great nationally renowned speakers who are on the forefront of this change. And I'd like to take a moment to thank all of the students that were involved in making this happen. They did an amazing job. Brittany Martinez and Chloe Castro, who led this effort. They put together our first ever app for a conference at Vermont Law School. Hopefully you've all downloaded it and looked at it. What an amazing job. Dean Jefferson and Kathy McCullough for their support, as always. Bill Bond and the rest of the IT folks who continually provide ongoing support to every conference that we give at Vermont Law School. The food service, who always surpasses our expectation, and I say that with lunch in the offering later today, so we compliment them in the morning. And last but not least, our students and our community at Vermont Law School, and our extended community of alums and the practicing attorneys who have joined us here today in lieu of the mid-year bar meeting. So thank you so much for joining us. And without further delay, I'd like to introduce our student leaders, Chloe Castro and Brittany Martinez.
Thank you, Professor Ikes. So I'll keep my remarks short so we can get started and finding solutions to some of the biggest issues we have in our community and society. First and foremost, I do want to recognize the SBA president that we have here today, Cody Stryker in the back. Stand up and wave, there we go. Thank you. The Solutions Conference is made possible by the SBA. We set aside funds every year, and students bid for a topic that they think is prominent in our community today, so that we can provide a platform for people to get together and find solutions for those issues. And without the help of the SBA and leaders like Cody, we wouldn't be able to put this together. So thank you for the representatives of the SBA and also Mr. President Cody Stryker. Quickly, I just wanted to speak on what inspired me to join on this platform of the Solution Conference. There's a lot of things that are going on, and sometimes we feel that we can just stick to the traditional route of how we can find solutions to some of the issues in today's society without thinking of what we have in front of us, which is the phone. A phone, a laptop, can do so much in this world. And I think with recent things that are going on in our community, in our world, in our politics, with our president and our candidacies and our presidential elections, I think we have become more and more concerned of how far can our information, how far can our activism reach when it comes to social change. And so when Chloe pushed forth this idea of the Solutions Conference and integrating legal tech as one of those platforms, I was definitely on board. I've been active in looking for using technology as a way of finding solutions, and having an entire conference focused on what those things look like. It's awesome. So just to give a heads up, this is a very dense topic that we're going to be talking about throughout the day. So if you can't capture it all, that's okay. Don't feel, defeated or sad or anything like that. The goal of today is just being introduced to this new world that is either we're going to be prepared for it or it's going to knock us down. And so we want to introduce what you should be expecting when you leave law school, what to expect that's going on right now, and have you guys start thinking of solutions to counter those issues that you might see are going to be permanent. Artificial intelligence, privacy information, personal identifiable information from laptops, from Facebook. Start thinking about these things today, because we need to start defining what that looks like and what the limitations are in the future. That being said, I hope you guys have a great time, and thank you for coming.
Yay, thank you all so much. My name is Chloe Castro. I will keep this very brief because I think that Brittany and Professor Ikes covered really the gist of it. I wanted to do the Solutions Conference because I, as an admitted visiting student, was scheduled to visit the Solutions Conference for that year in 2016. And it was a fracking event, and it discussed, why fracking is good and why fracking is bad. And I was blown away at the fact that we are not, as the #1 environmental law school in the nation, once again, we are not just looking at one side of things. We're really talking about both sides of things, and that was really impactful to me. And so I wanted to take on this project as a student here, and the most important thing that I think is at our hands that we're not using is technology and legal technology. And so we'll see how all of those legal technology and access to justice intersect, and what we can do and how we can help everyone in the community. So without further ado, thank you all so much for being here. I hope you have a great time. I'm going to introduce our first speaker of the day, Benjamin Battles. He is the Vermont Solicitor General. He submitted the amicus brief in support of the government for Microsoft v. United States, which was heard last month. Opinions before the Supreme Court of the United States, and the opinion is still standing, or still pending. So this will be an interesting discussion. You all have, also, just to give you a quick brief on the app, you can submit your questions on the app or on the website, vlslegaltech.com, if you don't want to download the app. And so you can submit your questions there. Otherwise, there are question cards in the middle of your table, and you can just bring them to us throughout the event. And you can see the conference program there. You can pretty much navigate your way through the conference there. Okay? Thank you.
Good morning, everyone. Thank you for being here today, and thank you to Professor Ikes and the law school for inviting me to speak today. As Chloe mentioned, I'm going to be talking about my office, the Vermont Attorney General Office's participation in the United States v. Microsoft case, which was argued before the U.S. Supreme Court on February 27th of this year. It's an interesting case, involves a lot of different issues, but the primary one is when can law enforcement access data that has been stored overseas? So I'll first talk a little bit about how the case developed and what the underlying facts are, and then I'll talk about how this issue came to our office and how we decided to get involved. The United States v. Microsoft case began in December 2013 when the federal government sought a warrant from a magistrate judge in the Southern District of New York in Manhattan. And the procedure that they used is called, it was under 18 U.S.C. 2703A, which is a provision of the law that's known as the Stored Communications Act, which was passed by Congress in 1986, so long before modern cloud computing and a whole different world as far as the internet was concerned. But there's a provision in this law that says when a government agency, state or local or federal law enforcement, needs to seek the contents of information that's electronically stored communications, that they need to go to a judge and demonstrate probable cause as they would for a traditional warrant. And then if the judge grants the warrant, then it is served on the provider, the electronic communications provider, who then must gather up the information and produce it to law enforcement. And so it's kind of a hybrid between a traditional warrant, which authorizes law enforcement to go and search and seize property, and a subpoena, which is typically served on an entity who then collects and produces the data. So it has the probable cause requirements of a warrant, but it functions much like a subpoena. So this was a drug trafficking investigation in New York City. The FBI and the U.S. Attorney in the Southern District of New York applied for a warrant under the Stored Communications Act. The magistrate judge granted their application, and it was served on Microsoft, who was the provider, and it had this individual's email address. And that's what they're looking for, the contents of his email account. Microsoft, upon receiving this warrant, determined that the information being sought was stored on a server in a data center that it had built in Dublin, Ireland. So upon learning that, it responded and moved to quash the warrant and said that it would be an extraterritorial application of the Stored Communications Act to require it to produce data from a foreign server. And so that was litigated in the district court. The U.S. government, DOJ, won the first round. It was appealed to the Second Circuit, and that's when the arguments really got fleshed out on each side. Microsoft, there's a line of U.S. Supreme Court cases, most notably Morrison v. National Australian Bank, and there's RGR Nabisco is the other case that talks about when a statute can and cannot be applied extraterritorially. Essentially looks at two issues. One, did Congress intend the statute to apply extraterritorially? And in this case, no one argued, there was no dispute that the Stored Communications Act says nothing about extraterritorial application. So you move on to the second part of that test, which is whether what is the focus of the statute, and is the conduct that's being targeted by the statute, is that occurring in the United States or in another country? And in this case, the federal government argued that this was a local investigation. There was probable cause shown that a crime had been committed in this jurisdiction. Microsoft was a U.S. provider, could access the data from within the United States and provide it to law enforcement within the United States. And the specific provision talked about disclosure to law enforcement. And so the disclosure was happening in the United States. This was a domestic application of the statute. Microsoft's response was, this is the Stored Communications Act. It's concerned with where information is stored, and it's concerned with protecting the user's privacy. And here, the user's information is being stored in another country. and you're requiring us basically to become an agent of the government and search and perform a search in another country, even though the person at the computer is sitting in the United States, that they're actually going, there is a physical process that's occurring in Ireland in order to retrieve this information. And some other, and tied into that discussion was whether, as I mentioned before, whether this was really a subpoena-like device or a warrant, because there's a line of cases, traditional warrants, it's very clear, cannot be executed extraterritorially, whereas with a subpoena, there's authority that, if there's jurisdiction over the defendant or whoever's receiving the subpoena, that it's their obligation to produce anything that's within their control. So that was a line of argument before the Second Circuit as well. Ireland actually came in and submitted an amicus brief in the Second Circuit. It's kind of explaining what their law required, which was very succinct. It basically said, we believe that our law applies to this, but we also believe that we have authority in the opposite situation to require a provider to comply with our service. So it's argued before the Second Circuit. Decision comes out, and it's a 3-judge panel. It's unanimous in favor of Microsoft, although there's a concurring opinion from Judge Lynch, which is very interesting, which basically talks about how important a tool this is, the Stored Communications Act. It's used by law enforcement on a daily basis throughout the country at all levels of law enforcement, and that the implications of this decision are that essentially it's completely within the provider's control to sort of thwart legitimate law enforcement investigations, whether, not that they're doing that intentionally, but just by their practices, they can move their data out of the jurisdiction and law enforcement won't be able to reach it, and talks about how, what tremendous problems this will create in a wide variety of contexts, from national security and terrorism investigations to online child sexual exploitation and a whole host of cases. But he ultimately concludes that in 1986, this was not something that Congress anticipated, was this law being applied extraterritorially. The government moved the Second Circuit for a rehearing en banc, and it went before and was re-argued before the full Second Circuit, which split 4-4. And so the panel decision stood and remained the law. And there's, I think every judge that participated in that decision wrote their own opinion, talking about either how this was, there was the 4 that agreed with the initial panel and talked about how this was clearly an extraterritorial application, and then the other 4 wrote very heated opinions talking about the terrible problems this creates for law enforcement, and how illogical it seems for an event that's occurring where everything's occurring in the United States simply because a provider decides to send that information overseas, that should be the deciding factor. And an interesting aspect of the Microsoft case, which came out, it was never clear in the record where the individual whose email account was being sought lived. It just was not in the record for whatever reason. I think it was fairly assumed that he was living in Ireland or in Europe, but it wasn't in the record. And so the implications of the Second Circuit's decision applied regardless of whether an individual was in the United States and their data had been stored overseas, or whether they were stored overseas because they were living outside of the United States. Microsoft's, their data storage procedures, as explained in the litigation, was that when someone signs up for an Outlook account or a Hotmail account, they are asked where they are located. And then based on their response to that question, Microsoft then assigns them to the nearest data center. Other providers, most notably Google, have a very different process where when you sign up for a Gmail account, they automatically do a process that they call chunking or sharding, where they take a single communication and they store it on different servers around the country, and it's or around the world, excuse me, and it's constantly in flux, and it's indexed, and I think they do this for a variety of reasons, for their own commercial reasons like advertising, and also for security reasons and backup reasons and network efficiency reasons. But because of the Second Circuit's decision, providers like Microsoft and Google and Yahoo, most notably, started taking the position in response to these SCA, Stored Communication Act warrants, that whenever they received them and determined that any data being sought was stored on an overseas server, that they couldn't comply. And so this started popping up around the country, and including in Vermont, and that's how we came to this issue. At the Vermont Attorney General's office, we have what's known as the Internet Crime Against Children's Task Force, which is a collaborative effort with other law enforcement in the state, but it's overseen by an investigator in our office. And after the Microsoft decision came out, there was several cases, all involving online child pornography and child sexual exploitation, that where we had probable cause to believe, and we went to a state court judge and said we have probable cause to believe that there's an individual in Vermont who's using a Gmail account to facilitate possession, distribution of child pornography. You know, in some of the cases there was potential victims that still needed to be identified, and so we had come to the court with an initial investigation showing probable cause and all the things I just mentioned. And in each of the three cases, the judge issued a warrant under, Vermont has a state law counterpart to the Stored Communications Act. And we obtained the warrant, and in each case, Google moved to quash the warrant and argued that, you know, because of their network, which I just described, first they said they couldn't locate where the data was at any given time, but they believed it was stored overseas, and then they later clarified that much of the data was in fact stored overseas, and refused to comply with the warrant. And this was kind of happening shortly after the Second Circuit decision, before the Justice Department had filed a petition for certiorari in that case. So we continued to litigate with Google, and around the same time we learned that the DOJ was going to seek cert in the Microsoft case. So we, because we had been litigating this issue and we really felt it posed a very serious problem to law enforcement, because it really was preventing us. I mean, as I mentioned, there was one of the cases where there was potential victims. There was an individual who, you know, there was evidence to show that he was, you know, assaulting individuals and continuing to have conversations and share child pornography with other victims, and we were not able to, you know, we weren't able to investigate the case as we thought the law allowed us and should allow us. So our task force and the folks in our office were pretty upset about this state of affairs, so we looked into whether we could file an amicus brief in support of the federal government's cert petition in the Microsoft case. And we eventually decided that we wanted to do that, and started working with our counterparts in other states, and also collaborating with the United States Solicitor General's office, who was representing the government in the U.S. Supreme Court. And we had a number of conversations with them, which, as an aside, was an interesting change of position, because in the at least in the last year or so, we're much more frequently at odds with the Federal Justice Department, and have filed a lot of litigation against the Trump administration. But on this case, we were in agreement about what public safety and law enforcement required in this situation. So we ultimately filed an amicus brief in support of certiorari. We got 33 other states at that stage, or 32 other states and Puerto Rico to join our brief. And after we filed the cert petition, the judge who was looking over the cases in Vermont ruled in our favor, and Google filed an immediate appeal up to the Vermont Supreme Court. Then shortly after that, the US Supreme Court granted certiorari in the Microsoft case, at which point Google decided that, I think it got a sense that the writing was on the wall, or at the very least that they didn't want to be contesting this issue while the case was pending in the US Supreme Court. So they agreed to comply with the warrants in our Vermont cases and dismiss their appeal before the Vermont Supreme Court. So that case is done, and I believe Microsoft as well. I think while this case, since cert was granted, all the providers, for the most part, are continuing to comply with these warrants. So this moved all the attention on this issue to the US Supreme Court. And we, at this point, I think our efforts on the amicus brief were on Microsoft's radar. I think we had been kind of under the radar prior to that point. And the DOJ filed their brief, and then we agreed that we were going to file another brief on the merits of the case. And at this point, Microsoft began a really pretty aggressive lobbying effort to both convince us not to write the brief and convince other states around the country not to join the brief. But from our perspective, we felt it was really important. We had already sort of said what we meant on this issue, and so we didn't really see any reason to back off at this point. And we ultimately did file another brief on the merits, got a couple more states, and so it was 35 states and Puerto Rico on the merits. There was not many other people on the government side in this case. A lot of, I think law enforcement felt very strongly about this issue, and we were sort of representing the law enforcement issue before the Supreme Court. But big business, tech, civil liberties groups, pretty much all the other players that often file amicus briefs in US Supreme Court cases were all aligned with Microsoft. In addition, there was a number of foreign interests, a few countries, including Ireland and UK, filed briefs in support of neither party, which basically urged the Supreme Court to basically just pay attention to international law. It said, whichever way you rule, you need to have a process to account for international comedy and the concerns of other countries who believe that when data is stored within their borders, that their law applies. A lot of the other amici on Microsoft's side were raising arguments based on privacy and concerns that allowing the U.S. government authority in this case would create a sort of slippery slope where other governments with less robust protections for privacy would demand that Microsoft comply with process in their countries and the other providers as well, and that there wouldn't be much of a basis for those providers to resist, given the U.S. government's position. And I think the final tally was there was about 3 or 4 briefs that took sort of neither position's party. We were the only brief on the government side, and there was about 37 briefs on Microsoft's side. And meanwhile, after these briefs was filed, things started happening in Congress on this issue. There have been efforts over the past 5 or so years to introduce new legislation that would update the Stored Communications Act and account for some of these issues. After the briefs were filed, a number of legislators sponsored a bill that's called the Cloud Act, which stood for Clarifying Lawful Overseas Use of Data, which directly addressed what was before the court in Microsoft. And it basically has 3 features. The first is clarifying that law enforcement, when they obtain a probable cause-based warrant under the Stored Communications Act, that does in fact entitle them to data that has been stored overseas. The second aspect of the law is it creates a formal mechanism for a provider to move to quash an SCA warrant, and based on international comedy, and it sets out a variety of factors to look at, including what the state of the law is in the country where the data is stored, whether that country has an agreement with the United States concerning law enforcement access to data. And then the final aspect of the law was create a mechanism, sort of a streamlined mechanism for different countries to enter into agreements with the United States concerning use of data under, the traditional process is something called a Mutual Legal Assistance Treaty, or MLAT, which is not directed at stored data. It's sort of predates it. I think these came about in the 70s, and it's basically just a mechanism for a country to, when they need to obtain evidence from another country, and it requires, if it's a local law enforcement agency, they need to go up through the United States Justice Department, I think with some assistance from the State Department, and make a request to the other country's central government, and then goes down to wherever the data may be. So it is an effective process in some situations, particularly if you need to interview a witness or things of that nature. It's very cumbersome in this context. It can often take months to complete, and particularly where you have data that's moving around the world, it's just impractical. Particularly in the Google situation, you would have to, data from a single email could be stored in 5 different countries on one day and a different 5 countries the next day. So there is just no practical way to use the MLAT process to obtain the data. So the Cloud Act, as introduced, creates this more streamlined agreement for data sharing. And a number of the players, it certainly didn't satisfy everyone. But it did have the support of the tech companies and did have the support of law enforcement. I think the tech companies' perspective was it sort of takes them out of legal limbo to an extent where they're facing conflicting obligations from multiple countries, and it provides a mechanism to address those concerns. And from the law enforcement perspective, it sort of preserved what the status quo had been before the Microsoft decision, was that absent exceptional circumstances, law enforcement can obtain data that has been stored overseas. So the oral argument before the Supreme Court was held on February 27th, several weeks after this legislation was introduced in Congress, and perhaps not coincidentally, and I went down and attended the argument. And not coincidentally, the lead sponsor of the Cloud Act, who is Senator Orrin Hatch, was seated in the front row at the Supreme Court argument, about 5 feet from Chief Justice Roberts. And the pending legislation loomed very large throughout the argument. And I think some of the first questions that the government got, who was Michael Dreeben, was an attorney in the U.S. Solicitor General's office, who was arguing for the government. He's also working on the Russia Special Counsel investigation, but I guess he took some time off to do his day job. Some of the first questions Mr. Dreeben got were why should we wade into this, and why isn't this an issue for Congress? And his response, which I think is right, is that this is an issue that Congress should address, but there's no telling whether or when they will. And in the meantime, you have a concrete case in controversy before the court, and this is an issue that's playing out all around the country in the lower courts. I think, there wasn't a circuit split in this case, but there was the Second Circuit decision, and there was about a dozen district court decisions and some state court ones, including from Vermont, that had ruled the other way in favor of the government on this question. So there were some questions about that. I think reading the court, they seem to be favorable to the government. They asked Microsoft some very difficult questions about the practical implications of their position. including Justice Alito asked a very pointed question of Microsoft counsel that says, imagine we have sort of the situation we had in Vermont where there's a crime, the crime occurred in Vermont, the person who's suspected of the crime lives in the jurisdiction, yet the provider, for its own reasons, has decided to send the data and has divided it up and sent it to countries around the world. Is it your position that the government then needs to go through the treaty process for each individual country? And Microsoft's answer, after a little bit of hedging, was yes, and I think that was just not satisfactory to the court. Although there was, it did sort of reveal, and this whole case does, how difficult it is to apply traditional, especially dated statutes to, which are necessarily territorial. They're passed by individual countries and individual jurisdictions, and how you impose this on a worldwide system of data storage and multinational and companies who are operating around the world and have operations and have customers in dozens of countries, and how you reconcile this in any way that makes sense. And there was a real tension as the justices tried to grapple with this, and they're asking questions about what exactly is happening in the United States, what's happening in other countries. And clearly all the human action was happening in the United States, but there is something happening in Ireland. There is a physical facility there. There is servers there, and there is a process when someone is from within the United States is querying the server in Ireland. In the argument they were talking about, robots. There's a robot in Ireland that comes in, which I don't know is the most apt description, but there is a mechanical process. And there is human involvement, at least to the extent that, humans built the facility, humans maintain it. They may not, it's not like you call someone in Ireland who then goes through the library and pulls the data, but there is a human element there, and the facility is subject to Irish law. My sense was just that the public safety implications of Microsoft's position would lead the court to rule for the government. I think they were trying to find a way there where it wasn't an all or nothing ruling. And one possibility that was suggested by DOJ and discussed a bit by the justices was that the providers have to comply, but if they assert that by producing the information they would violate their obligations under foreign law, then that could be something they could raise at the contempt stage, so they could be ordered to comply with a warrant, but then refuse to comply and say they should not be held in contempt based on equitable considerations because they had these conflicting legal obligations. And that seemed like the most promising possibility for the court to thread the needle in this case. I don't know if that's what they'll ultimately do. And as an added wrinkle, the Cloud Act, which I mentioned before, has now been tacked on to the latest spending bill, which passed the House yesterday and is expected, I think, to pass the Senate in the next several days. So in the event that passes, I suspect that Microsoft will argue, and I think DOJ may likely agree that the case is now moot, and that will be the end of the litigation, and then the Cloud Act will govern from that point forward. So with that description, I guess I'll answer any questions that anyone might have. I do. I think there have been efforts for the past several years that, even though they had a fair amount of support from different stakeholders, just didn't make it anywhere. But I think the Supreme Court agreeing to decide the case and the response, particularly from Microsoft's amicus, talking about kind of the slippery slope and what would happen around the world, and sort of the privacy implications of that really highlighted the issue for Congress.
Are you seeing companies putting into place procedures for how they're going to manage the data and to meet this kind of issue? I work at Oracle, and I know that we receive missives and, and instructions about retaining our emails, voicemails, all kinds of things.
Yeah.
Do you see this happening in other companies as well?
Yes, I mean, each company has their own terms of service and their own procedures for how they store data. And as this litigation has progressed, I think both, Microsoft and Google are who I'm most familiar with from this case, and they both have made some changes to their policies and their ability to sort of identify where data is. I also know, and this came up in a lot of the briefing in the case, that in other countries, I think particularly in Russia, laws have been passed requiring providers, I guess called a data localization law. And so it's if you're going to do business in our country, you need to store our Russian customers' data in Russia. And so that sort of eliminates the extraterritorial aspect of it, although I think from a technology and efficiency perspective is not satisfactory.
So my question is about the ultimate goal of this, because it seems like a lot of legislation put in place to catch careless criminals. So what about when the criminals utilize client-side encryption, and no matter how much you get access to the data, you still can't get what's actually inside of it?
I think that's a great question, and I don't think this case solves that problem. I mean, that's sort of the San Bernardino Apple situation, and I think that is a very interesting question, is whether law enforcement in that situation can require Apple or whoever to assist it, and that was what was being was starting to be litigated there, and then I think the government found a workaround where they didn't need Apple, but I think that question is still out there.
So my question's related. Wouldn't a ruling for the government just encourage more careful criminals who are going to find companies that are not subject to U.S. jurisdiction? I mean, Microsoft's a U.S. company, so it stands to reason that the government has some jurisdiction over them. But a Swiss company or a Russian company, all its servers are out of the country. It seems like a cat and mouse game where the government's just going to continue to lose unless there's a greater overall worldwide scheme.
I think savvy criminals already do that and will continue to do that, and that is a problem. And I think that's the sophisticated criminal is always going to be making sophisticated moves to try to avoid law enforcement. But under Microsoft's position, at least the cases that we were involved with, this was not the sophisticated criminal. This was someone who was just interested in child pornography and was doing that. We talked with, in our brief, we talked about some other examples from around the country, including there was I think it was in Wyoming, where someone had emailed an arson threat to a Wyoming hotel, like shortly after another motel had been burned by arson, and they immediately went to the provider, said like, we want to see this guy's emails to see what he's, try to find him, and they're like, oh no, we store that, over the country. And I think there's the sort of run-of-the-mill criminal cases are not going to present that problem, but there is always going to be the sophisticated criminal who's trying to stay one step ahead.
So I would ask if you think the GDPR and the incoming regulations in Europe are going to impact this, and how they will impact it? And is everyone becoming more closed and more private with data?
Yeah, and that's I believe the General Data Protection Regulation. And that, was discussed in the briefing, and I think that's the new law that's governing EU countries. And it wasn't in effect at the time of this litigation, although I think it's coming very soon.
May.
And my understanding of the Cloud Act is that through the sort of bilateral agreement process, that is an attempt to sort of reconcile and create that kind of dialogue with other countries. Arguably there are some exceptions in the GDPR that would apply to this situation that hasn't really been litigated yet. But the broader question of whether people are becoming more closed, I think governments are just becoming more aware and are taking a variety of responses. And I do think there is an increased effort to sort of assert jurisdiction over data that's stored in a particular country. And that's what I think what the GDPR reflects and what is going to need to be worked out in the coming years.
Okay, we're going to accept one more question if anyone has, and then we'll get ready for our first panel.
So building off my first question, as data security and privacy gets better, ideally we'll be going towards client-side encryption anyways. So then your average user is using these technologies to protect their privacy and security. And then wouldn't the Fifth Amendment protect them from disclosing their private key that allows access to their data, and therefore eliminate the whole issue of being able to subpoena that data? Because again, it's not accessible. The only way to get it is through the original accessor of that data. And granted, we could go around that and try to say, hey, is there anybody else who's willing to share their email data, give permission? And I think that's possibly the direction we need to go in order to accomplish these things. But where do you see, I guess my question would be, the next step? This legislation, I think, is a Band-Aid in some ways to a current problem that needs to be addressed. But then where do you go from here once you see this start to, seal up the envelope, and where's the next step?
It's a tough question. I don't think I have a good answer. It's a great question. Yeah, I think in that context, I don't think you can force someone to unencrypt their device for you. If you're law enforcement, yeah, but then they say no, and so I guess they say no, and you charge them with violating that law too. But but I think everyone's. I don't know if there's a good answer. Certainly government is trying very hard to make sure that they have the best people or access to the best people to sort of to be able to solve these problems. And but it's kind of like an arms race.
Thank you.
Thank you.
Great, thank you so much. Benjamin Battles, everybody.
Thank you, everyone.